Supreme Court or High Court, which is superior and which is inferior? What is the real truth about the judicial hierarchy? And what Supreme Court has gone ahead and clarified. High courts are not inferior, but when Supreme Court speaks, everybody must stay silent. Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh and today we are going to understand the main quote that has come in a recent case by Supreme Court that yes, high courts are not inferior and in any scenario Supreme Court is not superior, but at the same time when a matter is seized by Supreme Court, it is their own matter and there is no interference that should take place by high courts as well. So the important question here is, what is the judicial hierarchy that we need to understand? What are the constitutional provisions? What happened in this case? What was this case about? So let us start with understanding this case first. So when we talk about this particular case, there was a case that was going on and Supreme Court was monitoring the whole Central Bureau of Investigation probe, especially into the illegal construction and tree felling, especially in the Corbett Tiger Reserve. This is also an example that you get to see of judicial activism in environmental governance. We'll talk about this also by the end of it, but let's understand what happened in this scenario. Now, the Supreme Court was monitoring this whole probe and in this matter only, Supreme Court went ahead and directed the Uttarakhand government so that they grant the prosecution sanction against a specific officer. Now, this particular officer went to the Uttarakhand High Court with a writ petition. Can you tell me in the comment section which article gives the provision of writ petitions? I will be talking about this later, so you will get to check your answers also. So herein, this writ petition was filed by this particular officer in Uttarakhand High Court and now this High Court stayed the sanction order. Now you have to remember that this sanction order was given by nobody else but the Supreme Court itself. And the problem is when the High Court is saying to stay the sanction order, it is coming in between when the Supreme Court is already actively monitoring a case. So as a result of all this, what happened? Supreme Court came up and told that High Court cannot interfere in a matter which is seized by Supreme Court. It clearly warned also that there can be no parallel proceedings and at the same time there was acceptance of officer's apology because he went to Uttarakhand High Court, but the case has been as of now transferred from High Court to Supreme Court. Now that we have understood the matter, let us break this down and understand what are the issues with it. But before understanding the issues, it becomes very important to know the constitutional framework or the constitutional provisions that exist for judiciary with special reference for Supreme Court as well as High Court. So when we are talking about constitutional provisions for Supreme Court, we must understand that it is from Article 124 to 147 which gives the provisions for Supreme Court, be it the jurisdiction, be it the powers, be it the functioning, and then we have Article 214 to 231 which talks about the constitutional provisions for High Courts. So this also ensures High Courts independence and High Courts also have the constitutional status of their own. At the same time, when we are talking about writ petition or writ jurisdiction, it is available to both. It is available to High Courts, it is also available to Supreme Courts. So when we are talking about writ jurisdiction for Supreme Court, it is given in Article 32 and there is a direct enforcement of fundamental rights which can be seized through this particular petition. But when we are talking about Article 226 which talks about writ jurisdiction of High Courts, this is where we see that High Court can issue writs for enforcement of all rights. So this is the main difference that you get to see here. Furthermore, if you talk about Article 141, which becomes important for us to understand because it tells that law declared by Supreme Court is binding on all courts and it establishes a clear hierarchy where Supreme Court is placed at the top of this hierarchy. Furthermore, we also find in Article 142 further expansion of Supreme Court's power, which talks about that Supreme can do complete justice. In this situation, we not only get to see expansion of Supreme Court power, we also get to see that they have these powers in all pending matters in front of them. And lastly, Article 144, that all authorities to act in aid of Supreme Court. So here we get to understand that High Court, which is the point of matter in this scenario, it is expected to respect the proceedings that are going on in Supreme Court. Now, I guess these three articles would have given you the clarity that what are we talking about. We are not taking away the constitutional status that High Court has, but at the same time, we are establishing the fact that Supreme Court, if they have seized a matter, if the matter is at their hand, then they have the right to do complete justice. The law that will be declared by them, that will be binding on all courts, and it should be in facilitation of SC. The other courts are operating, they should aid Supreme Court. So this gives a fair clarity. Yes, High Court cannot be placed inferior, but High Court does not get to interfere also in the matters of Supreme Court. Another important thing that came out as a Supreme Court's observation through the bench of which included our CGI B.R. Gawai, it also included Justice K. Vinod Chandran and N.V. Anjaria, which clearly remarked that High Courts are not inferior to the Supreme Court. But the very next statement also brought in the clarification that when the Supreme Court is seized of a matter, they are involved in a matter, they have taken up the matter, then the High Courts have to show and must show respect and refrain from any parallel proceedings on that very specific matter. Another highlighting that came from this very case is the fact that the majesty of law lies not in punishing but in forgiving. This key quote is in reference to the apology that was accepted by Supreme Court of the officer, and these are the two major things that came through the Supreme Court's observation in this particular case. Now let us decode this further. This led to certain court's action. What were those actions? As I have already mentioned, first, unconditional apology was accepted by the officer, and there was also a rebucation of High Court for interfering in the petition, and there was also the order of transfer of the matter, which was a pending matter, from High Court to Supreme Court, so that High Court understand as the matter has been seized by the Supreme Court, it stays with them. Now I have used this term quite a lot, that matter is seized by the court, or you can say when Supreme Court is seized. This is a legal doctrine that makes it important for your exam also. So let us break that down. So when we are talking about seized, it means when the Supreme Court has already taken the cognizance of the matter and it is already actively hearing the matter or monitoring the matter in this particular situation. So once Supreme Court is seized, that means no other court should pass conflicting or even similar but parallel orders. So if the proceedings are going in Supreme Court, they go there only. It cannot be run parallelly in other courts. Second, there should be proper prevention of judicial chaos and any sort of forum shopping. In this situation, that means there should not be an option for the person to go and check the options with other forums, which happened in this scenario because the Supreme Court asked for prosecution sanctioned by the Uttarakhand government. In this scenario, the officer went to High Court. That means he is looking for other forums in this situation. And once Supreme Court is seized, it also ensures that there is a proper finality and unity of command in the whole judicial supervision. That is why this legal doctrine becomes very important, and that is what has been highlighted in this scenario. We have seen this in previous cases also. So the relevant cases in this scenario are, for example, State of Rajasthan versus Union of India of 1977, where there was a conversation that the judicial propriety in concurrent jurisdiction should remain. Furthermore, we have A.R. Antulya versus R.S. Nayak of 1988, which talked about hierarchy does not diminish independence. That means if we have understood that we have Supreme Court as the apex court and then comes the high courts, this is a hierarchy, but that doesn't mean that high court is not independent. It remains as an independent entity and it holds constitutional status as well. Other than that, we have T.N. Godavarman case versus Union of India, which began in 1995, and this outcome, the court's action we are talking about, is part of this case only, where we have seen Supreme Court monitoring forest matters. That means Supreme Court has shown judicial activism. Some might mark it as judicial overreach also in environmental governance. And then we have Delhi Judicial Service Association versus State of Gujarat 1991, where we understood that all authorities must aid Supreme Court. The clarification was given on Article 144. So these are certain examples that will help you understand this better. You can use them in your answers and in case studies where you want to quote them. Now moving ahead, that we have understood the relevant cases, let us move to understand the finality, what exactly has been concluded. So when we talk about the constitutional balance, as I said, independence is separate, hierarchy is separate. Similarly, independence is separate, discipline is separate. The discipline that should be maintained by high courts with their independence. In this scenario, the clarification that has been understood is the fact that high courts have the status where they are constitutional courts, but at the same time they require to respect Article 141, where the binding precedent is sent by Supreme Court. Furthermore, if you talk about judges which are appointed under Article 217, they are not subordinate to Supreme Court judges, but at the same time, there should not be any conflicting jurisdiction, and most importantly, there should be application of Article 144 that all authorities aid Supreme Court. In short, Supreme Court is not superior, High Court is not inferior, but if a matter lies with Supreme Court, then what they set is going to be binding on all courts. High courts cannot interfere in their matters, there should be no legal proceedings, and high courts should aid the Supreme Court. Now we have understood the whole context here. Now let us understand the final clarification, as I have already mentioned this, that Supreme Court said the judges of high courts are in no way inferior to judges of the Supreme Court. But the most important thing here is the judicial discipline, which needs restraint when the apex court is already seized. I hope it got some clarity on this particular observation that came from Supreme Court. Now moving to the thing that I started with, that there is presence of the component of judicial oversight in environmental governance, where we see that the long-running T.N. Godavarman series on forest and wildlife protection, which started in 1995 and it's still ongoing. SC has been supervising not just the investigation into illegal felling, but also they have been taking accountability of state officers, they have been sanctioning orders, prosecution orders, they have been putting them out. This clearly shows that there is judicial activism which is present in environmental matters, and it also helps us to understand and also reinforce that when SC monitors an issue of national importance, then it is important that high courts, even with their independence, maintain consistency with what Supreme Court is doing. Because in this scenario, two different verdicts were given by High Court as well as Supreme Court. Now on this note, I'll be leaving with you a practice question. Here is a list of writs and their purpose and meaning, and you have to match them based on this code. You can put your answers in the comment section. I'll be coming up with the answer in the next video. That was all from my side. Thank you so much.